Charges dismissed. Trump finally wins in court. Well, not so fast. Yes, obviously I am not in my normal LegalEagle office. I'm actually in southern Utah because I'm participating in the off-road games that I'm definitely going to lose because I'm the only one that doesn't have off-road experience. So that's fun. But this is a really interesting legal ruling from Judge Scott McAfee in Georgia in the Georgia election interference case. It's super interesting. It's super wonky from a legal perspective, and a lot of people are reporting on it wrong. So of course, we've got to cover it here on LegalEagle. Yes, Judge Scott McAfee's had everyone on the edge of their seats wondering whether he would disqualify Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade from prosecuting Donald Trump because they had a romantic relationship while the case was being investigated. But instead of ruling on that motion, Judge McAfee dealt with some other pending motions, including the defense's motion to quash some of the counts of the indictment. Judge McAfee threw out 6 counts in the 41-count indictment, including 3 charges against Donald Trump for his alleged efforts to persuade former Georgia House Speaker David Ralston and Georgia's Secretary of State Brad Raffensperger to violate their oaths of office by refusing to certify Joe Biden's victory. These efforts included Trump's so-called perfect call, where he pressured Brad Raffensperger to find him just enough votes to win.
All I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
The judge concluded that the, quote, lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. So what does that mean? Well, Trump now faces 10 felony counts in Georgia instead of 13, for now. This is certainly not the end of the Georgia prosecution, as some have reported. And Judge McAfee's ruling left open the possibility that the state can seek a fresh indictment on those charges if they include the right language. So what does this mean for the case against Trump, and what happened legally? Well, defendants filed a motion to quash the indictment by way of a special demurrer. In Georgia, the special demurrer is a request for a more definitive statement or an explanation of the charges. Quote, a special demurrer challenges the form of the indictment by claiming that the defendant is entitled to additional information or specificity. It asks the prosecutor to particularize the conduct that an alleged crime was committed. And generally, a demurrer and a motion to dismiss are essentially the same thing. They look only to the allegations and assume them to be true. They're testing the legal sufficiency of the indictment. They're not testing the sufficiency of the evidence that has been presented. In fact, trial hasn't happened, so there hasn't been any evidence really presented to the finder of fact. So why did the defendants say that the indictments were defective? Other than, claiming that the phone call was perfect. That doesn't work. That's actually a factual claim, not a legal claim. And I'm sure Trump will be allowed to make that legal defense at trial, but this special demurrer was testing the legal sufficiency of the indictment as written on legal grounds, not dubious factual grounds.
People have been saying that it was the highest vote ever. There was no way. A lot of the political people said that there's no way they beat me, and they beat me. They beat me in the poll. As you know, every single state, we won every state. We won every state house in the country.
And here they argued that the indictments did not give the defendants enough information about how they solicited Georgia officials to violate their oaths of office. They raised 2 key issues. And the first issue was whether the indictment should have specified which parts of the oaths the state officials would have violated if they had gone along with the defendant's scheme to give the state's electors to Trump. The second issue was whether the indictments were specific enough about the parts of the U.S. and Georgia constitutions the defendants allegedly violated. Again, this is wonky, in-the-weeds procedural stuff that generally you don't see in really famous cases, but this is sort of the blocking and tackling of being a trial lawyer, is arguing these really minute issues of detail. And on the first issue, quote, defendants first argue that the indictment is defective because the charging language does not cite the oath each of these solicited public officials were required to take. In fact, the Georgia state officials don't all take the same oath. Georgia senators and representatives must take an oath prescribed by Georgia Code 28-1-4. The governor takes a different oath. The Secretary of State takes a different oath prescribed in a different section. And there are subtle differences between each one, and the indictment doesn't say which parts of these oaths the various defendants violated. Now, Judge McAfee ruled that, quote, this omission is legally harmless because, quote, precedent is clear that the allegations must either include every essential element of the predicate offense or charge the predicate offense in a separate count. And in this case, all 3 statutory oaths contain some linguistic variation, a provision that the oath taker will support the Constitution of the United States and the Constitution of Georgia. So the indictments didn't need to go into specifics about which parts of their oaths the officials would have violated. However, the defendants were correct about the second issue, whether the indictments weren't specific enough about which parts of the state and federal constitutions were allegedly violated. Now, if you've ever had a perfect call that has led to a witch hunt in multiple states, you're going to want a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click on the link below. So let's start by looking at count 1. Count 1 is for the Georgia RICO statute. That indictment says that the defendants committed 161 overt acts in furtherance of their corrupt RICO scheme, and the entire case is anchored by the RICO charge. That charge remains intact. And then count 2 says that Trump, Rudy Giuliani, John Eastman, Jenna Ellis, and Ray Smith unlawfully solicited, requested, and importuned certain public officers to engage in conduct constituting the felony offense by unlawfully appointing presidential electors from the state of Georgia in willful and intentional violation of the terms of said persons prescribed by law. And then Act 3 of count 1 says that, quote, members of the enterprise, including several of the defendants, made false statements in Fulton County and elsewhere in the state of Georgia to Georgia officials, including the governor, the secretary of state, and the speaker of the House of Representatives. Members of the enterprise also corruptly solicited Georgia officials, including Secretary of State and the Speaker of the House of Representatives, to violate their oaths to the Georgia Constitution and to the United States Constitution by unlawfully changing the outcome of the November 3rd, 2020 presidential election in Georgia in favor of Donald Trump. So one of the acts charged by count 1 involved convincing the members of the Georgia Senate Judiciary Subcommittee to act on Trump's behalf by submitting a different set of electors to the Electoral College. That's the event referenced by count 2. And Judge McAfee explains the way the indictment is designed. Quote, the indictment, when detailing the manner and means of the criminal enterprise alleged in count 1, describes the defendants as soliciting Georgia officials to, quote, violate their oaths to the Georgia Constitution and the United States Constitution. Thus, reading the indictment as a whole, which the trial court is required to do, confirms that these are the prescribed terms at issue in the 6 challenged counts. That event, the subcommittee meeting, is charged as a separate crime in count 2, but the judge says that the indictment language of count 1, whether it says to violate their oaths to the Georgia Constitution or to the United States Constitution, is simply too generic. Quote, while the averments do contain a reference to the terms of the violated oaths, this court finds that the incorporation of the United States and Georgia Constitution is so generic as to compel this court to grant the special demurrer. On its own, the United States Constitution contains hundreds of clauses, any one of which can be the subject of a lifetime study. Academics and litigators devote their entire careers to the specialization of a single amendment. To further complicate the matter, the Georgia Constitution is not a mere shadow of its federal counterpart. And although some provisions feature similar language, the Georgia Constitution has been interpreted to contain dramatically different meanings. This is in marked contrast with, say, aggravated assault with a handgun, which can be perpetrated, quote, in only a limited number of ways, and an indictment that merely refers to a handgun is not too vague because it infers that the weapon was used either as a firearm or as a bludgeon. So the language about the Constitution just says that the defendants violated their constitutional duties, but doesn't say which ones. So the provision should have named which parts of the Georgia Constitution the state officials would have violated if they went along with Trump's plan. For example, Article 1 says no person can be deprived of property without due process. Article 2 says no person can be denied equal protection of the laws. So if the indictment alleged that the state officials violated their oaths of office, thereby denying someone the right to have their vote counted, that might have passed muster with Judge McAfee. And you might think that Trump and the other defendants should be found guilty of every single charge. Or you might think that Trump and the other defendants should be acquitted of every single charge. But this is exactly the kind of careful analysis that you really want in a trial judge. Judges should sometimes be skeptical of prosecutor statements. At this point, let's put on a picture of Spencer. Yeah, you should definitely be skeptical of prosecutors' statements. Maybe especially as here, where an indictment is so voluminous and complex. But the judge here did not say that the defendant's conduct was incapable of satisfying the elements of the crime. Quote, the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged in abundance. Yeah, that's the kind of language as a defense attorney you don't want to see written about your clients. But the judge goes on, quote, however, the lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. As written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission, i.e. the underlying felony solicited. And as former federal prosecutor Renato Mariotti put it, quote, indictments need to be specific enough so the defendants know what crime has been alleged. But there's a big caveat here. Judge McAfee concluded the quote, "However, these pleading deficiencies do not apply to the corresponding overt acts listed in count 1, specifically overt acts 23, 42, 55, 102, 112, and 156. Overt acts alleged as part of a conspiracy are not held to the same pleading standards as statutory-based offenses. Defendants have not provided any authority requiring that the particulars of an overt act be alleged or subjecting overt acts to the standards of general or special demurrers. The defendant's challenge to these overt acts is therefore denied." So in practice, that means that the criminal counts that have been dismissed are gone, but the related overt acts survive. For example, Trump's call to Secretary of State Brad Raffensperger can still be used to prove the racketeering charges against all defendants. Mark Meadows is probably in the best position after this ruling, since the only count remaining against him is related to that call, but he's still being prosecuted as a RICO conspiracy defendant. Now, that doesn't mean that the district attorney is out of options. The DA's office can theoretically re-indict quickly. If there's a grand jury on the premises, it could happen almost immediately. But that process is a little cumbersome compared to what happens in federal court, where the prosecutor can just file a bill of particulars to inform the defendant of the charges in sufficient detail to minimize the surprise at trial. But Georgia law doesn't have such a provision. Or the state can appeal. The judge notes that alternatively, the state may request a certificate of immediate review pursuant to Georgia code, which the court would likely grant due to the lack of precedential authority. But that would obviously pause the case while the appeal is litigated. Or the DA might simply choose door number 3, letting the ruling stand without filing a superseding indictment. The same conduct is covered in the RICO count, because theoretically the DA only gets one more shot to properly indict the conduct, because if the state loses a second special demur, then the state isn't allowed to replead after that. Now, if the thought of Trump getting off scot-free made you lose your appetite, I have good news, because you can get it back with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things that you actually want to. And I can personally attest the meals are fantastic. Plus, you'll never get bored with what you're eating. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan and veggie, and more. And on top of that, Factor offers 55 add-ons that help make your weeknights even more delicious and nutritious. And now Factor is offering 2 free wellness shots with each order for life while you're an active subscriber. Factor meals arrive at your door pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I could even think about going to the grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook, and it's surprisingly affordable too. And now Factor also offers Gourmet Plus meals as part of your weekly options, which means you can get a little gourmet with your meal plan whenever you're craving something special, because you deserve it. Gourmet meals include surf and turf or surf and surf, shrimp and salmon. But honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs creates each meal to help you feel your best all day long, and they really are extremely delicious. Like my favorites, bruschetta shrimp risotto, green goddess chicken, and grilled steakhouse filet mignon. And Factor is flexible. You can pause or reschedule deliveries at any time. In fact, this is making me hungry. So click on the link below or the link that's on screen and use the code LegalEagle50 to get 50% off your first Factor box. Again, to get 50% off your first Factor box and get free wellness shots for life, just click below. After that, click on this link over here for more Legal Eagle, or I'll see you in court.